Guys, hear ye, hear ye. Supreme Court is now in session. The Honorable Judge Cree has the floor. You may be seated. Yeah. You have to.
Three Amish fathers, Jonas Yoder, Wallace Miller, and Aiden Yutzi, were fined $5 by the state of Wisconsin for yearly refusing to abandon their religious beliefs in order to follow the intolerant state statute. It should be well known within the Wisconsin state government that the Amish practice a set of beliefs that often conflicts with the idea of separation from church from state, such as refusal to educate children past the 8th grade. It would be in the best interest of the Wisconsin state government to read upon the Constitution as this practice is protected under the free exercise clause of the First Amendment. Thank you.
Mr. Chief Justice and Mrs. Justice, may it please the court. An Amish family living in Wisconsin is fighting for the right to take their kids out of school for religious reasons. The state of Wisconsin has a law that states all parents must send their children to school until age 16, making this situation unokay. They fought over the fact that the First Amendment protects their right to take their children out of school for the right to freedom to practice any religion they want. Argued on December 8, 1971 and decided May 15, 1972. The case focuses on whether or not Wisconsin could require all that parents send their children to school at least until age 16, and if it violated the First Amendment by criminalizing the conduct of parents who refuse to send their children to school for religious reasons. The court is reviewing the decision in the Wisconsin Supreme Court holding that the respondent's sentence of violating the compulsory school attendance law were invalid under free exercise clause. If Wisconsin infringed upon the Amish family's individual rights under the free exercise clause, the First Amendment proposes is to ensure everyone's freedom of expression is protected, which includes the free exercise clause. Thank you.
Co-counsel.
Our position that Yoder in favor of the state of Wisconsin is supported by the following precedents. One is the 1925 state case of Pierce versus the Society of Sisters, in which the court ruled as the high responsibility for the government to provide education to its citizens, and they can impose reasonable regulations of control over basic education. Secondly, in Ginsburg versus New York, a 1968 case, this case was ruled in a court of the 6 of the current 9 Supreme Court justices, and 5 out of those 6 justices voted in favor of the state of New York. This case involved a prohibition of distributing inappropriate and sexual images to minors, and this precedent of this case said that New York's penal law section 484H, which was in question, was not unconstitutional under the First and 14th Amendments, that they could regulate sexual images to minors. Finally, in Gillette versus the United States, a Supreme Court case of 1971, the nearly identical court that stands before us said that the activities of individuals, even when religiously based, are often subject to regulation of the state. When 2 soldiers decided that they thought that they could, that it was under the First Amendment that they had the right to not perform their duties in the military, and this court struck that down, saying that their interpretation of the First Amendment and the free practice of religion, they were taking that right too far. Finally, under Wisconsin law, not only is public school an option, but they have the option. The parents of the Yoder children, they have the option to provide education themselves. It is as it is stated under the Constitution of Wisconsin, it is the right of the parents to provide an equivalent education in a privately operated system if there is no public education funded.
Co-counsel.
So, our position, of course, supports the.
Hang on, Mark.
What?
Danielle, you're still doing opening, right?
You're still doing.
They have three people doing opening.
Hey, what comes after opening?
Just do your opening, and then we'll take a recess.
Is this just the opening?
This is just this is
Just
the
the opening statement.
Opening argument?
opening arguments.
We argue, first, some form of education is necessary to prepare citizens to participate effectively and intelligently in this country's political system. Second, we argue, education composes individuals to be self-reliant and self-sufficient participants in society. Lastly, we argue that exempting the Amish children fails to recognize the children's substantive right to secondary education, giving due regard to the power of the state government authority as a legal protector of citizens unable to protect themselves. In conclusion, Your Honor, we ask the court rules in favor of Wisconsin because our state law requires all children to attend school, and we believe that it is in the best interest of the children to attend school in order for them to be active members of society. Thank you, Your Honor.
Our position is also supported by a following precedent in the case of Sherbert versus Varner, which ruled that an infringement of the free exercise clause occurred when the state government of South Carolina imposed a burden on Sherbert's ability to freely exercise her religion by denying her request to withdraw from work on Saturdays, the Sabbath day of her faith. This case sets the precedent for the religious rules protected by the First Amendment, being unrestricted by state laws because they go beyond the power of state to control. Constitutionally, First Amendment's purpose is to separate church from state and allow the freedom of religion and the practices that come with it, no matter what the faith is. In this certain situation, the Amish are protected by their rights, which are protected under the Free Exercise Clause. They have the right to conduct their religious rituals without any intervention by state or federal government. Therefore, it is unlawful and unconstitutional for these fathers to be fined for simply standing up for their beliefs, which as American citizens are under the protection of the U.S. Constitution. Thank you.
Short recess.
Okay, so we will now take a short recess. Everybody knows what a recess is. It's just a short break. The justices will probably speak to each other, and then we have the next phase. Yeah, you have a question? Yeah.
Did they start calling it recess like before,
Kind of confused.
like schools called it recess?
Yes,
I thought it was just the opening statement, but he literally took everything I was supposed to say.
he did, and that's okay. But that's okay. But that's
I mean, I have a different.
that's the beauty of the first time we're ever doing this,
Yeah.
because it's okay.
Were we not supposed to say that?
It's supposed to be an open. No, it's fine. We're just going to
It's supposed to be
continue.
like a background, right?
We're gonna. What you'll see in court a lot is repetition.
Yeah.
So that's fine. Don't worry about it.
Alright.
So you'll give your piece.
Yeah.
So we'll get to the next groups. Okay. So we have arguments for Yoder, Max, and Ayana, and we have rebuttal arguments against Yoder, Gemma, Bryson, and we're back in session, so everyone will be silent, and Chief Justice Long will call upon the argument for Yoder.
Mrs. Chief Justice, may it please the court. Mr. Yoder was tried under a Wisconsin law for not sending his kids to attend public school. He believed it conflicted with his family's religious beliefs as an Amish Mennonite. The state of Wisconsin disagreed with the fact that Amish Mennonite family refused to send their kids to public school as a violation of state education law. However, the First Amendment's purpose is to protect citizens from being limited to exercise free religion. We ask that the court rule that Wisconsin state law requiring kids until 16 years old to go to school is unconstitutional, violating freedom to practice religion. Our position is supported by the following case, Prince versus Massachusetts, where the court ruled that the state was responsible for general welfare of young people, therefore letting these adolescents come home to their families to practice their religion freely. In conclusion, Your Honor, we ask that the court rules in favor of Yoder because Wisconsin is directly going against the right to practice religion freely. Thank you.
As Nelson Mandela once said, education is the most powerful weapon which you can use to change the world. Wisconsin built its constitution with this knowledge that children are our future. Children need to have education to be able to have the success in a country like ours. Regardless of religion, Wisconsin's constitution does. Children need to have an education to be able to have the success in our country. Regardless of religion, Wisconsin's constitution does not violate the First Amendment, since it simply sets a requirement that helps better for the children's future. On the rational basis, secondary schooling will help the children to gain a better understanding on the society by educating them with the survival skills they need in our society. No matter what your religion is, education is a mandatory human right. Moreover, the Wisconsin state law was a reasonable and constitutional use of government power. While the right use of government's power on children's education plays an important role in protecting students' rights of attending secondary schooling.
Co-counsel?
Your Honor, the government's law applies to not only the Amish children, but also extends to all other students who have religious background under the Constitution of the Wisconsin state. The Amish children are free to practice their religion without punishment, but taking them out of school before they have reached the time of 16 is irrational and illogical. Our country takes pride for freedom, but we cannot neglect the importance of education over the free exercise of individuals. The Supreme Court's decision will affect students profoundly since it sets exception on all the students who have religious background by comparing the individual's rights under the First Amendment. It is the future of the children, not the parents, and their choices on secondary schooling should be heard instead of the choices of parents. The Amish tradition forbids the students to enter the world of diversity that we have today. But does the Bill of Rights in a way block the religious student from choosing their own destiny?
Short recess, everyone.
So this is the point where the judges would deliberate, ask questions. Do you guys have questions prepared to ask, or you've been taking notes? And if you do, we'll just kind of shout them out and have each side raise their hand and you can call on them. Okay, so you have questions, right?
Yeah, I have a question for Yoder for that side. So when it came to like the discrimination, I guess, from Wisconsin, was there like physical discrimination? Like not like physical, but like where was the state like, you know, not harassing, but was it like were there like discriminatory things back and forth between the state and like the children about not going to school? It was like the only thing was. Do you understand what I'm saying?
Somewhat. Alright, well, no, I don't think there was any harassment or, I'm a little confused on your question, but,
Like
um,
when the parents decided to not send their children to the Wisconsin state like public schools because of religion, did you feel that like Wisconsin public schools were treating your like students, not students, but like children like differently and like
no, they,
discriminating
we don't
against
feel
them?
they were treating them differently or, well, we feel they were discriminating against their right to practice religion freely, I guess.
Mm-hmm.
So there wasn't any like additional like poor behavior towards them. It was just the whole point of the case is that they're denying the family to, I guess, practice their religion and go to a private school.
And also, it's not so much a discrimination, it's also the intolerance.
Mhm.
I think the government of Wisconsin knows the Amish are very isolated and live by their own rules and practices, and one of those just happens to include not educating kids past age 16 and sending them to public high schools. And that's because they want the kids to work on the farm to actually get the proper training, so when they're older, they have the proper skill set to actually support their families. So it's just intolerant that they would take that right away from the Amish.
Yeah, and every citizen in the United States has the First Amendment right, even though they're Amish and they separate themselves from society, and they don't have the same norms as other people. They work on the farm most of the day, but they're still guaranteed that right, I guess.
They're still Americans.
Just for clarification, was it the two parents and the child fined, or who was fined, and for what for?
3 fathers were fined $5 for refusing to send their kids to high school.
And did you know if the kids had any say in it, or were the parents keeping them out? Not really. Did they listen? Did the kids want to leave, or?
Since they were minors, they were keeping them out of the whole conflict, because I guess they're not really old enough to speak to the Supreme Court judges, I guess, because they're minor. You have to be an adult. Yeah, you have to be an adult to represent yourself in court.
Oh yeah, I'm not saying that they speak in the court. I'm just asking, did the kids have any say in whether they could go to school or not?
No.
Okay. Thank you.
Did you have your hand raised?
Yeah, I was just gonna say that the reason why the 3 fathers didn't want their kids to go to high school, to go to the public school, is because they don't want to expose their kids to values that might go against their own religion. So if the law requires them to send their kids to school, then it on some degrees violate their rights to practice their religion.
Make sure you speak loud and clear.
Yeah.
It's okay.
Okay. Okay, I have a question for Wisconsin. So, do you believe that your requirement violates the First Amendment by criminalizing the parents who forbid their children in your schools for religious reasons?
Well, first off, it doesn't criminalize them. They were just being given a fine. But it is illegal for them not to provide some sort of education. And this is not something that is very hard. They don't have to send their children to public school. Under the Wisconsin Constitution, the parents have the right to provide their own education, so long as it is supervised by the state. They can teach their as long as they're teaching their children material that is approved by the state. They are allowed to not attend public schools if they want. They are allowed to be homeschooled. They can work on their farms in any way. There's absolutely nothing that violates the First Amendment in our Constitution that requires them to have some sort of schooling.
Since the Amish lifestyle is mainly, they all live around each other and themselves, and it's kind of like their own sustained community. Isn't them learning their type of education, learning from their parents by staying home and practicing the Amish lifestyle?
Sure, that is a form of education. However, our state believes that setting a precedent by changing our Constitution, which we believe is a perfectly fine document, that it could set precedent for people to just leave education whenever they want, and parents for them to abuse their children by taking them out of school whenever they feel they desire, and it's more important for the children to learn so that they can become productive members of the society, and not only that, but then they're still allowed to practice their way of life and in their Amish community, in the Amish community.
Alright, take a short recess.
So, all rise. This is when the Supreme Court justices go to their chambers to deliberate and make their ruling.
Are they walking out?
Please be seated. We're much more informal. So the two of you now make your ruling and your closing, or what your decision.
Are we supposed to?
Okay.
Oh, no, it's fine. You can listen. It's not. This is a Supreme Court case that happened in 1972, so it's not like there's no spoiler alerts, right?
Are they allowed to rule differently?
Yeah, Yoder won 1972, right?
Are you asking me for the result of the case?
I'm just double checking. I'm pretty sure
Did it? They won.
All rise. Please be seated. The Honorable Chief Justice Long.
So should I say like my opinions first and then like the ruling?
Mm-hmm.
Okay. Well, I'm gonna start with this. So I understand where you guys are coming from with the whole, sending your kids to school kind of thing, and like you have to until like 16. I get that whole thing, and yes, Yoder was not following that. I understand that, but I don't know, it's just like when it comes to the First Amendment of freedom of expression and like religion and stuff, that sort of, like jumps in there. So I'm in favor of Yoder because they have the right to express what they want to do. Like the Amish, they have their own rules, they have their own religion, so they can practice it in any way they can. If they decide not to go to your schooling because they are educated in a different way, then they can. So that's
Is that the unanimous decision of the court?
Yeah, the decision is in favor with Yoder, because, although they have their set regulations and stuff that everyone else follows by the state, Amish people, their civilizations, they're totally apart from everyone. They don't use electronics. They do everything like how that used to be back then. So if they choose that they want to send their kids to school, and their type of education is by growing up on a farm and working every day, then that's the education they'll get.
Is this a unanimous ruling or is there dissenting opinions?
No.
This is unanimous? Okay. You can bang your gavel. Okay. Court is over. Give yourselves a round of applause. So first time we've ever done this, right? So take this as a on-site learning experience. This is the first time we've done it. Okay. So what I want you guys to do now is fill out a reflection sheet. Okay.
Who actually agreed with Wisconsin?
Who agreed with Wisconsin in real life?
No, in here.
The Wisconsin one case.
No, Yoder did. Because they'd be knocking on
Well,
the Amish.
can you do homeschooling?
But their homeschooling is them working and farming and
visit
stuff.
the Amish and they go to school.
Yeah.
So,
I don't know.
I'm gonna transfer to an Amish school.
Good luck. I sent a Snapchat for you.
I don't think you have the same success with recruiters.
Come watch it. 30 long.